Good morning, everyone. I'm Kimberly Chalier with PHCA. Thanks so much for joining us for today's webinar. A few quick updates to share before we get started. This webinar is being recorded and will be made available on the PHCA website. The webinar has been approved for 1.5 continuing education credits for all PHCA members in attendance. As we begin today, all attendees will be in listen-only mode. Please feel free to submit your questions via the chat icon at the bottom of your screen, and we'll make sure to answer as many of those questions as possible. I know at one point in today's presentation, we will invite everyone to engage with our presenters. If you have an interest in engaging, utilizing the talk feature, please raise your hand and I will take you off of mute. I will now turn today's webinar over to our presenters. Amanda, you can take it from here.
Good morning, everyone. Welcome. My name is Amanda Thompson. I'm the General Counsel for SnapCare, and we are delighted to have the opportunity to talk to you all today about this pressing and relevant issue that is in all of your spaces. The difference between 1099 and W-2 treatment of employees / contractors is something that's been an issue as long as I've been practicing law, 25 years. But with the new rule that's coming out from the DOL, it really kind of brings things to a head and makes it more important than ever that we all look at how we're doing things and look at ways we can do things better. And so we're just happy to be here. So thank you for being here as well. Our agenda for today, I'm going to introduce our panelists. Well, the three of us are all lawyers. I am in-house. Samantha is at Fisher Phillips, which is actually where I got my start practicing law. They are a wonderful nationwide labor and employment firm, and so experts on this issue as well as many others. And then we have Rob, who will introduce himself. He was my predecessor in this role, but he moved on to do bigger and better things and is now the Chief Revenue Officer overseeing revenue operations. So I'll introduce them, and then we're going to give you an opportunity to share with us what you're feeling, what you're sensing out in your day-to-day practice with the labor shortage, all the issues that are presented in the healthcare space, what you guys are feeling, so we can be sure to address it. We want to keep it kind of casual. If you have questions or thoughts or you want to share anything, please do. We want to be a resource for you and answer your questions and make sure that what we're presenting is relevant to you. And it's an opportunity for some free legal advice, if nothing else. So then we will go into the background of 1099 versus W-2 and what this new rule does. And then we'll really dive into how it affects you and what the specifics of, staffing and contingent labor can do for you and how these rules will affect you. So moving to the next slide, introductions. I'll start with Samantha. Do you want to give a quick introduction of yourself?
Sure. Thanks, Amanda. And good morning, everyone. Thanks for being here. I'm happy to be here. As Amanda said, I'm a partner at Fisher Phillips in Philadelphia. We're a labor and employment boutique firm that really kind of covers any aspect of law that would cover the workplace. And so I typically practice in advice and counseling, some traditional labor and litigation. I do quite a bit of wage and hour. So I'm the nerd that thinks this is really interesting and fun. So hopefully I can, provide some background and guidance for you guys today. Before coming here, I was actually in-house for a while at Universal Health Services. So I do have that kind of the aspect of being, on the ground in the business and trying to figure out what to do when there's all these changes. So happy to be here.
And next we have Rob Edmund. Go ahead, Rob.
Thanks, Amanda. Good morning, everyone. As Amanda mentioned, my name's Rob. I also am a lawyer, so started my career in private practice, was a partner with a Midwestern firm, represented about 10 to 12 different staffing companies that spanned light industrial to tech to healthcare. Also represented a fair number of hospitality companies. Then about halfway through my career, went in-house, was in-house counsel for a few different publicly traded companies, including one tech staffing firm, and then was general counsel at a hospitality company. So those have been kind of the two main industries I've served over my career. I was also chief people officer at those companies. So started to branch into operations really early in my transition to in-house. And now I've kind of made that switch full scope, right? So I'm here wearing an operator hat today. I lead our sales, credentialing, recruiting, and compliance teams here at SnapCare. And so have really had to take the lawyer hat off a little bit and think very pragmatically as an operator in the space, how we make a lot of this work for our clients. So that'll be a bit my role today is representing the agency voice and how we're reacting to some of the things that are happening in this space and how we're trying to help clients navigate it.
Thank you. Thank you. So what we want to do to start this presentation is to see if any of you would mind sharing your feedback about what you're seeing and feeling right now in healthcare staffing. What are your pain points? What are your wins? Are there any bright spots in what you're experiencing? And we'd like you to feel free to take yourself off mute and ask the questions live, or you can put it in the chat feature. But we'd love to know what some of the things you are feeling these days, and also anything that you would like us to touch on that's particularly relevant to you and your facilities. Don't be shy. Oh, whoops. Anybody?
Someone's got a thought. So I'll throw one out there. Is agency a bad word in your world right now? It is, I think, for most of the clients that we serve. How many are feeling that? Come on, not all at once.
Oh, we have
All right. We've got a quiet crowd, and that's fine. I think
William's got his hand up here. Hopefully we can get him off mute.
I can't see, but I can hear.
Kimberly, were you able to take William off of mute?
Yep, I've actually invited Bill to come off of mute. He just needs to unmute himself.
Okay, can you hear me?
We can.
Yes, sir.
Okay, yeah. Agencies are a bad word, yeah.
That's what...
Yeah, we when we have shortages, we unfortunately to meet minimums for our medical team, we have to use these agencies, and their fees are really excessive. So we end up paying, in some cases, 3 times more for a worker. The other problem, or not, the other challenge is if you find a good agency worker, a lot of them had contracted, and so you can't just hire them on a regular basis. They would be penalized if they came to you and worked directly with you. So there's issues with that. And then, of course, you have a high turnover. We're faced with that challenge too. We've had situations where people have come as nurses' aides, and we've begun the training. And after a week of training, they just don't show up. They found something better, maybe $1 an hour more, and that's really an ongoing challenge for us.
That's rich feedback. There's at least 3 nuggets in that I heard, right? Just the sheer cost, the reliability, right? Bailing in an assignment or just not seeing the assignment through, especially after you make an investment in training. And then conversion fees and other kinds of fees, things that keep the labor captive and away from you when you find someone good that you might want to convert to perm or have be part of your permanent staff, another pain point, right? So all very rich feedback.
Yeah, and that's feedback that our teams have gotten when they've spoken with our clients and potential clients and worked through with healthcare associations and trying to determine, what the needs are out there. So thank you for sharing that, Bill. And I think we'll address some of that during our discussion today. Does anyone else have a question or a response to this question?
Susie,
I
I
see.
see that you shared some feedback in the chat. If you wouldn't mind coming off of mute to elaborate more, I'd appreciate it.
Sure. This is Susie. I'm not sure what more there is to really say, except that, the financial damage that has been done to long-term care from a variety of factors involving the pandemic, but probably the biggest one is to the cost of staffing and all of the ripple effects that agency, our reliance on agency during the pandemic and the I suppose exodus of healthcare workers. It's just it's hard to say. It's a bit of a chicken and egg situation, but I guess at the end of the day, it has been financially devastating to long-term care, and we're starting to see a gradual shift. It's just not fast enough, and it's not big enough.
Yeah, I think
Absolutely.
I can hear the exasperation in your voice, Susie, a bit. And I would say, it's not uncommon. We hear this from a lot of our clients, and it is, Amanda's going to cover this in a second, but there are all kinds of financial pressures mounting all at one time in the long-term care space, and surging demographics. And so you just got a lot of pain in a lot of places, but some of the most acute is in the labor picture, and some of that was practices, especially during the pandemic, and wage inflation in the pandemic that staffing agencies helped to fuel, right? So not here to defend that, but we have to acknowledge that right out of the gate.
Absolutely. If we don't have any other chats or sharing, I can move to the next screen, which I think, Susie, you could probably present this screen. You and Bill both touched on the things that we are noting and realizing through our work with our clients and getting out there and trying to determine what the problems are and what the solutions we can provide are. So this is a kind of a graphic showing what we see as all of the pressures that you guys are feeling. We've got the aging population and surging demand for long-term care and senior facilities. So does anyone know, some of you probably do know this data, but from the US Census Bureau, 19.6% of the Pennsylvania population is over 65. And that's going to increase, or it's predicted to increase to 30% by 2030. So in the next 6 years, it's going to increase significantly. And even where we are now has increased from 2012 by 28%. So it's an aging population. They're there and they're going to need our help. They're going to need your help. So you have that combined with the labor shortage that is, as Susie said, it had started during the pandemic and it's just gotten worse since. And then combine that with the compliance mandates, and you guys are in healthcare. We've got to make sure that we're complying with all the regulations out there, but also providing an excellent and quality experience for your residents and your patients. And then of course we have the wage inflation. We're seeing that. And so these are all the things that I think we've recognized that you guys are feeling. And so, So with that, I'm going to hand it over to Samantha to discuss what we're here today to talk about, because really how you classify your employees, I think it can provide an outlet for lower costs, but in some cases it's lower cost for potential long-term exposure. And so that's what we're going to discuss here. Samantha, you want to take it from here?
Yeah, thank you, Amanda. So I'm sure all of you are aware of, W-2 versus 1099, and that's why you're here today. But we just wanted to go over some of the basics in terms of how it's working for your operations. If you're using the independent contractor model, your clinicians are reporting their own taxes. They have to carry their own insurance. They're typically paid, the same rate for all hours worked, no overtime. We're not withholding the taxes. we're not carrying malpractice insurance on them, that sort of thing. And we're not doing record keeping in terms of wages and all of those things, versus a staffing firm that's using the W-2 model where they're actually employing the individual as their employees. And with that, of course, comes compliance with the Federal Labor Standards Act and paying minimum wage or overtime where necessary, withholding and matching reporting taxes, providing insurance as required by law, like workers' compensation, unemployment insurance, making sure to track time and keeping those records. And, you typically, if it's a full-time employee, they would have benefits coverage. And I think something that gets lost on a lot of clients I see is that whichever model you use or how you classify a worker, it actually has nothing to do with what the business says or what the employer says. It's the objective test from the Department of Labor, whichever statute you're sort of dealing with. And I hear over and over again from clients in different sectors, well, but this is how everybody does it. Like, why would I change it? They're an independent contractor. And sometimes I think it's lost that it, for better or worse, it doesn't really matter what we think. It's really whether they can meet the standards of the requirements under the law. And from the Department of Labor's perspective, they sort of break it down pretty easily that an independent contractor is a worker who often owns their own business and usually enters into contracts with employers to perform a specific project for a short-term period. And employees are employed on a regular basis by a single employer. And that seems to be, as we'll talk through a little bit more this morning, where the DOL is sort of going. They really want to make that transition to an independent contractor is really someone who is in business for themselves and contracting versus an employee or a worker who can come in and maybe come in and fill in gaps where needed, but there's no business initiative there or entrepreneurship, that sort of thing. So why does the government care? We'll talk a little bit about agency sharing in a bit, but especially when we're talking about employee classification or worker classification, I think the FLSA is top of mind for most businesses when it comes to employees. But there are a lot of other rules and regulations that are implicated if a worker is misclassified. So in terms of wages, they're guaranteed minimum wage and overtime. And if they're misclassified and not getting those benefits, then they're arguably underpaid. If they're offered benefits, there's benefits protection. ERISA governs a lot of those things, and there's regulation around that. Most of the full-time employees would be offered that versus independent contractors that don't have insurance. One thing I'm not sure is, spoken about enough is in terms of worker safety. OSHA has its own rule on what it means to be self-employed. And if you're self-employed, then OSHA has no jurisdiction in ensuring that you have a safe workplace. And then, of course, tax collection. If we're not withholding taxes or the employer's not withholding taxes, then obviously the IRS is getting quite a shortfall there. And we hope that workers are doing that and reporting as they should, but we're not involved in that, and we aren't. If you're doing it as an independent contractor, that doesn't fall on the business. So there are all of these reasons and different agencies, whether it's the DOL or OSHA or the IRS, that are coming together that all have impacts on this. And so, as I'll note a little bit later, but we've heard from the General Counsel of the National Labor Relations Board, which would also be implicated here. They are starting to do agency sharing that, if you have independent contractors and we think they're employees, and we find out maybe there had been some unionization rumblings, but it was denied, it was ignored because they're contractors. Now the DOL might go to the NLRB and tell them. And so there's a lot at play here. And, spoiler alert, they're all different tests. So if you're an employee or an independent contractor under the FLSA, that's not necessarily the same as the IRS or OSHA or the NLRA. So that can make it a bit tricky. I think it's worth noting, why are employers interested and why are business owners here today? I think it's because, at bottom, we want to pay our employees properly. And I think that gets lost in translation when discussing these issues because, perhaps there's a scare tactic when talking about these changes, but businesses want to pay their employees properly. I do truly believe that. And I think you're mitigating a lot of issues on the back end when you do that. So I think as often as it seems to be butting heads, sometimes it actually we're going towards the same goal, and it's just figuring out how can we do that, lawfully. Okay, so this is sort of the meat of the legal parameters around what we're talking today, and this is, understanding the new test for classifying a worker as an independent contractor. And I won't go too far back into what was the test and what's no longer relevant. I always joke with my husband that he'll tell me, don't turn left instead of turn right, and it drives me crazy. So I won't get too much into that. But as most of you are probably aware, for many, many years, the DOL used the economics realities test. And it was a totality of the circumstances with 5 factors, which were the nature and degree of the individual's control over the work, opportunity for profit and loss, the amount of skill required, degree of permanence, and whether the worker is part of an integrated unit of production. And under that test, there was no one factor that weighed more than another. And it was sort of a balancing to see which way it would sort of come out. And then in 2021, the rule was changed and adopted a 5-factor test, but pulled out 2 to say these are kind of the overwhelming that matter the most: the nature and degree of control of the work and the opportunity for profit and loss. And so if those go in favor of seeing as a contractor status, then the rest can sort of go by the wayside. And so that's what, a lot of you've probably been working under, and we'll talk about in a minute. While it might make it easier, enforcement has been going on for quite a while, regardless of that rule versus the current one. So the one that is, breaking next week, March 11th, we're returning to the economic realities test with a few changes. One is there will be a new factor added, which had been used in some prior administrations, but going back to investment by the worker versus the employer, and then the other factors that we just talked about. But some of the changes, we're not just going back to how it was. There's a few more things that have been kind of bolstered. Degree and nature of control. So this is going to be significant because the rule actually says that we're looking at the potential control, not actual control. So if it's a role in which the worker maybe coming in doesn't have a lot of control over what they're doing, but as they get up to speed and train and you realize, they'll end up having the employer or the business will end up having more control as they get up to speed. They can actually look at that even if it hasn't occurred yet. Another big focus is going to be on investment. If the independent contractor doesn't own their own tools or equipment, then the employer is going to come out, on top of in terms of which one's providing the equipment. Similar to like a roofer, if you've got someone coming in to replace your roof, typically you're not the one that would hand them the tools and the shingles and all of that. So that, kind of goes with the traditional contractor. But when they're coming into a healthcare facility and you're giving them all of those tools, that would weigh in favor of employment status. There have been some challenges to the rule. We don't see, interestingly, there are 4 different lawsuits, all Texas, Georgia, Tennessee, and Louisiana, and they are asking for an injunction to pause enforcement until it's worked out. But none of this lawsuits actually ask for a delay in implementation. So, unless there's a really speedy ruling, I I don't know that there'll be any delay. It might get paused later, but as of now, we're full steam ahead for March 11th.
Can we pause here for a minute and see if anybody has any questions? I accidentally jumped ahead on a slide, but do we have any questions about what Samantha's saying? She's really just laying out the law and kind of showing the evolution of the law. Anybody want to put a question out there or put something in the chat? Okay, I'll go ahead and move forward. Samantha's next slide.
Sure, thank you.
Mm-hmm.
So a few references to healthcare staffing, and as I sort of mentioned earlier, this isn't new in the sense that there's always been enforcement actions and a lot of activity in this realm. And so I wanted to share some recent sort of statistics. In September of 2022, the Department of Labor obtained a consent judgment to recover $9.3 million and liquidated damages for over 1,700 employers in a Philadelphia healthcare staffing firm. So that's under the 2021 rules, to my point that, it's not like there was a safe harbor and now it's gone. And in fiscal year 2021, the Department of Labor recovered $13.8 million in back wages in the healthcare industry in general. And one thing I thought was interesting, I dug into some more localized statistics in terms of Department of Labor enforcement in Pennsylvania, New Jersey, and New York. And you can kind of filter by number of citations. And so, there are many, many. So just looking at the top 10, 7 of those were in either healthcare, home care, or medical transport. And the other 3 were all in separate industries, which I think is really eye-opening in the sense that, it really is a vast majority, and it is a vast majority where we're sitting and operating. And actually, I think this Amanda mentioned earlier, I don't know if it was the same quote, but this was from the Department of Labor in Region 2, which is Philadelphia. That as the U.S. population ages and demand for home healthcare services increase, employment in a variety of healthcare sectors is projected to grow 16% between 2020 and 2030, which is faster than average of all occupations and adding about 2.6 million new jobs. So, that's compelling as we see things going forward, and how are we going to classify those roles and how are they going to be regulated and enforced by different agencies. So state law risks, if I haven't already confused you, I'll let you know the other news that a lot of states have totally different tests, or some that are just a little bit different in terms of what is an independent contractor under state wage and hour rules. I think the most common that this group would likely see that's different from the Department of Labor is what's called the ABC test. And that is used in a lot of states, including California, Illinois, New Jersey, and Massachusetts. And a worker is considered an employee unless the hiring entity establishes all 3 of these prongs here, which is the worker is free from the control and direction of the hirer in connection with the work, both under the contract for the performance and in fact. So, your contract isn't enough. The worker performs work that is outside the usual course of the hiring entity's business, and the worker is customarily engaged in an independently established trade, occupation, or business of the same nature. So this is certainly a higher hurdle in the sense that it's almost easier, because I think it's easier to fail it, but it's easier to say yes or no one way or the other, right? Because if I think even in New Jersey, the regulations have an example of a plumber. And so if you're a healthcare facility and you have some plumbing needs, you bring in a plumber. That has nothing to do with your underlying business or what you're doing. That's an independent contractor. But if it's something that is germane to the business, under this test, it's not an independent contractor. And some of the ABC tests among different states are different, even based on how it's weighed. So some states put the presumption of employment status, and then the hiring entity has the burden to prove that the worker is not an employee, which makes it a bit harder. So there are a lot of tests out there, and even when they look similar, the burden shifting is different. So it can get pretty complicated. There are common law tests in different states. Pennsylvania is pretty similar to the federal rules. And the focus is that, how much control the hiring entity has in the freedom. And then, of course, we get into the different state law or federal rules that I talked about earlier in terms of IRS and different agencies. So there are a lot of moving parts and a lot of different rules here that we wanted to point out because they can make it even more difficult to establish an independent contractor relationship.
Before we move to the next slide, I know what some of you might be thinking as you listen is, well, these are individuals employed by or independent contractors of the agency. So I'm not hiring them as an employee. I'm not hiring them as an independent contractor. And that kind of push and pull is something that we'll discuss later in the presentation.
Yeah, that's a great point, which we'll get into in terms of joint employer issues. So here, the factors that weigh in favor of classifying workers as W-2. So this is sort of breaking down those factors into some more, real world things that you're seeing in the workplace. Are you providing training? Do they carry their own insurance policies, or are you or the staffing agency providing that? Do they require supervision? They're coming in and who's calling who's overseeing their work. In terms of scheduling, I think we think of when sending in healthcare professionals where needed, we think, oh, they just get to, they're picking their shifts. We don't have any control over that. But is it, here's what's available and you can pick one, or they truly can say, well, I'll go in tomorrow and work, 8 to 8, or I'll do this or that, and they actually have the autonomy to pick the hours, which is different than just choosing from a set shift that's already been provided. And showing business initiative, this is one, as I mentioned earlier, I think the DOL is really focusing on that. They want to see that the contractor is actually in business for themselves, whether it's they have an LLC or they've got a website or business cards that they're holding themselves out as a business owner that can help your agency or your facility and many others, and have that initiative for profit and loss and things that are indicative of, like I said, I think in a perfect world, the Department of Labor would want every contractor to actually be an incorporated entity. Tools is a big one, and I think that's big in this space because, especially with traveling nurses and things like that, I would assume they're using a lot of the tools at the healthcare facility versus bringing in their own, which, back to my analogy of a plumber or a roofer, that can be easy to detect, but also depending which way it falls, it can help you figure out where you should classify here. And another big one is how long the worker has been working for you, because typically, like I said, it's someone coming in for a short assignment to take care of something that you don't typically employ people for. And, I think in this day and age, which with so much turnover, as we talked about earlier, this might not be as much of an issue as it is in some industries where you've got independent contractors that have been contracted for 10 plus years, which typically would be indicative of an employment relationship. So this is something I think that's important to keep an eye on in this industry, because I think it's sort of a moving target depending on how things are shaking out.
Before we move to the next slide, just a couple things I wanted to highlight on this, right? So in the preamble to the new rule, there's an interesting back and forth. There were thousands of comments made in the rulemaking process for the rule to be issued. And a lot of them were made by healthcare agencies, some 1099 and some W-2. IntelliCare and Gale Health are actually quoted 7 or 8 times in the preamble. And there was a kind of a soliloquy between kind of a call and response really between their comments and then some of the platform providers that are 1099 in the healthcare space and specifically in the long-term care space. And they centered on these themes. They centered on these arguments, right? And in every single case, the Department of Labor sided with the point being made by IntelliCare and Gale Health and indicated that in their view, the argument was not sufficient to make the worker a 1099 worker, and instead they should have been classified as a W-2. And so what do I mean by that? Let's go into a couple of these. Like, so workers' comp and insurance policies is an interesting example, right? If you check your contracts with a W-2 staffing provider, typically you're going to see we will provide workers' comp. We will provide all of the insurance policies. You'll also see some assurances that those policies are provided in a 1099 contract. But the issue is, how are they provided, right? It doesn't matter in the Department of Labor's eyes that 1099 staffing firm has a policy for medical malpractice or for general liability or even for workers' comp coverage. What matters is that each and every single one of the individual clinicians has their own policy because they're independent business people. And it matters not, the other thing that the Department of Labor said there was, it doesn't matter that they are, if they are just given one choice by the platform company and they have to enroll in the platform company's insurance policy, that's not employment, or that's not independent contractor, that's employment, right? So even though they might carry the policy, they're basically carrying the policy on the single choice provided to them by the 1099 platform. And that's not enough. That's not independently running a business. That's basically doing what that platform is telling you to do. It's following their orders, right? So that was an interesting point, I thought, in the commentary. Another interesting point in the commentary was, around this point around, choosing shifts, right? Most of us, most of our clients have shift needs, and the shifts, they set the shifts, right? They've got times when they need folks to work. And there was a back and forth there that says, look, if what you're doing is offering a set shift and not having the worker choose the shift, that is indicative of a W-2 relationship, not a 1099 relationship, which I think is that's a little bit new. And that was a more specific guidance than I've seen the Department of Labor offer previously on that. And I think it's got a number of firms in the space scrambling a bit, going, how do I make that work? Right? Because we plug into our client shifts. That's not something we can move around easily.
Yeah, those are all good points, Rob, and kind of building off of what you were saying in terms of choosing the insurance. I remember one thing from the commentary that says, one of the things we're looking at is investment. Who's investing more, the worker or the employer? And the fact that a worker, it has to take on the investment of malpractice insurance is denied. It's not an investment in terms of they're in business for themselves or indicative of an independent contractor relationship, as some people in the comments had, organizations had tried to argue, well, that's showing, investment on their end. And so that shift of the hiring entity investing in them and looking more like an employee, now they're doing it themselves. And so that's been rejected, which I think was interesting. Okay. So how does this affect you? So we've talked a lot about this. We discussed, multi-million-dollar orders and verdicts in the industry. But, it doesn't stop there. As we talked a little bit about the integration of these agencies, there's penalties from the IRS for failing to withhold, damages for not providing benefits if you otherwise would have if they've been properly classified. But beyond that, I think sometimes we don't think about the anti-discrimination laws and leave laws and all the other myriad of things that could be impacted if you're deemed to be a joint employer. So for those of you that use a staffing firm that in this scenario, if it's a 1099 model and that there's, action taken or a lawsuit filed claiming, there were violations of various laws, I think I'm sure you're all aware of the risk of joint employment. So whether, it was your obligation to have them as a W-2 or not, if you're deemed as a joint employer, could be brought into that action. And so that sort of opens the door for, if they were misclassified and not provided paid sick leave under a state's law, that can be implicated, or denied FMLA, or any of the other protections that employees have that independent contractors don't. So these are all things that, that a staffing firm may be denying based on, lawfully based on this classification. But then if it's found otherwise, it can be a problem. So
if I can interject, I'm sorry, real quick, I'll just an anecdote from my private practice. I represented a small staffing firm, and along with those risks, each of those risks is a potential opening. So the staffing firm that I represented, it wasn't healthcare, but they had someone who filed an EEOC charge. And this was someone who had been treated as an independent contractor, but she thought that she had been discriminated against. So she filed the EEOC charge, and the EEOC investigator immediately went to, and before I got involved, I'll say, they said, responded, well, no, she's an independent contractor. We are not subject to these laws. And that's when the investigator, eyebrows raised, antennae up, and immediately started pursuing, well, wait a second, why are you treating them as an independent contractor when it's clear that they're employed? So each of these things, someone files for workers' comp, someone files for unemployment insurance, someone files a claim that they weren't provided with maternity leave. Any of those things can be the opening that gets the government involved in looking into, wait, are these employees misclassified? So each potential risk is also an entree into the government seeing that there's an issue. I'm sorry, go ahead, Susie. I'm sorry, Samantha.
No, you're fine. No, that's absolutely right. And I think, in terms of the agency sharing, we're seeing so much, more and more about that. Even at the EEOC, to your point, you get a disability discrimination charge. We say it's not an employee, and then they could have had FMLA. So they asked the DOL to get involved and investigate. So it is, and, not that, in terms of the plaintiff's bar, it takes one claim to go to a plaintiff's attorney, and they say, oh, wait, you're an independent contractor? Well, let me ask you all these other questions and, build a kitchen sink approach. So I think that's just something to keep in mind, that while we're talking about mostly in terms of the wages and FLSA, there's a lot of other implications. We could do a whole day on the implications under the National Labor Relations Act. They have changed their standard to make it more difficult to establish contractor status. And for the first time in my career, I'm seeing many charges at the National Labor Relations Board from individuals who are not in a union, because they're still covered by the act, to challenge things, or, if they want to go that route, they can say I was misclassified and I tried to bring a union in. And we're seeing a lot more action on that side. So just sort of another example that there are so many ways that this can get brought to light, whether it's by another attorney or an agency.
Do we have any questions? I think I see something in the chat. Let's see here.
That was actually just me reminding everyone to get involved, ask questions, give input as they see fit throughout today's presentation.
Wonderful. Okay.
So this is an interesting article that, hits close to home for most of you, I would say. And I think that staffing agencies are really going to wise up here, that they can't, there is going to be impact on the hiring entity, or, the healthcare facility. And obviously, as we've talked about, nursing home staffing agencies have popped up with the pandemics. It has exacerbated the staffing benefits, and so have the litigation pitfalls. And we keep sort of seeing the same issues coming up and litigated. And we accept this to sort of be a surge in misclassification as things go forward. So there's some interesting sort of language here Pennsylvania operator Comprehensive Healthcare Management Services was sued in March of 2023 for $19 million due to unpaid overtime. And the operator brought on 1099 workers through Clipboard, a staffing agency with a 1099 model. The DOL has not yet sued the company. So, I think, and I know Rob will probably mention some of this, but in terms of indemnification and different things, I think will impact how people or how entities are brought into these issues. When I was, in-house, typically if it's, we would fight for indemnification language, and you often don't see a lot of that when it's a 1099 from my experience, versus if you're going to, as the staffing firm, take on the W-2, these are my employees, you're confident in that, you might be more likely. So this is it'll be interesting to see in this case whether the Department of Labor ends up bringing in the actual healthcare facility to see. Sometimes, it's a question of deeper pockets or how they want to handle that or what the underlying contract says. So with that, I will pass it to you, Rob.
Yeah, and often, so we do see the Department of Labor is suing both the client and the staffing agency on occasion. More typically, the litigation pattern is sue the staffing agency first, secure a judgment or a settlement indicating that they were in fact employees, and then sue the underlying entity for any remaining liability or lay the path for EEOC or other charges to come, right? Because once you establish that they were misclassified, you then have they're clearly employees and therefore joint employees. And that's the litigation strategy the Department of Labor and the EEOC tend to pursue against clients. So we've seen some pretty big judgments against both clients and against the staffing agency. The primary target is the staffing agency, but they do go after clients from time to time, both to make the point and to collect the full scope of the judgment, right? So if they're not able to collect against the staffing firm. So, what are we seeing? What are staffing companies doing about the new rule? What am I seeing in the industry? What are some of the practices here that can help you navigate this? Look, I've watched this over the course of my whole career, right? So I've been doing this close to 25 years now. And in that time period, this kind of comes in waves, right? So throughout that time period, I would tell you my best estimate is north of 80% of all companies in this space are W-2 providers, right? And sometimes that goes higher than 90%, sometimes that gets close to 100%, and sometimes it comes down to 80%, depending on kind of waves and influences out there and people wanting to push the economic model. Before, call it 2010, it's pretty uncommon. It happened. There were definitely 1099 providers in the space, but it was much more uncommon. When Uber kind of came on the scene, it became a bit of a wave of folks to say, hey, let's see if we can also classify as 1099, right? And there are a number of reasons why the analogy doesn't hold up. Drivers are not the same as workers who do what your other fellow workers do in your facility, and that's really the Department of Labor's point, right? And so there's reasons why that analogy has broken down over time, and the Department of Labor, every time they've litigated this, they've won, to my knowledge. I'm not aware of a single case where the lawsuits have come out in favor of 1099 status. But the law is gray enough that people still try, right? And people still try to classify as 1099. This new rule does make it even harder than it ever has been to classify workers in the long-term care space, healthcare staffers in the healthcare space as 1099s. So we are seeing kind of our peers and some of our competitors change practices and do some things in response. I would also note, look, in our own history at SnapCare, we started as a 1099 company, right? So we were founded in 2017. We started out as a platform company looking to supply 1099 PRN workers. We watched the landscape, right? So as we kind of got our foothold in the market as a 1099 provider, we came to the conclusion about a year and a half or two into our existence as a company, we're seeing a lot of these lawsuits go against the staffing agencies and their clients. We thought at the time the responsible thing to do to protect our clients was to convert to become a W-2 employer, and that's what we are now. We have been for the last several years. That's not an easy decision, right? Because you're walking away from more competitive business, right? We would love to offer our clients lower rates. 1099 providers typically can, but we came to the conclusion as a company that wasn't the responsible thing to do and to expose our clients that way. So we made that switch, and you're seeing that wave happen again, right? Every time these rules change, the industry steps back a bit, and some players in the market will change to a W-2 model. The reason that's not easy to do, as I'm sure many of you can appreciate, you got to set up whole new systems to make that happen. When we went through that transition, we had to get a payroll system in place, and that's not an easy thing to line up. We had to get benefits providers. We had to get insurance policies we didn't previously have, right? There's a lot to do to become a W-2 employer and do it right. So that transition, I think, will take some time, but we do know some significant players in the 1099 space have made the decision to go ahead and convert, and they're working on that conversion. We know that because some of their employees are out there looking for new employment in part of that transition, and they're trying to do the responsible thing that they see in light of these changes, right? So that's one response. I think another response we're seeing in the market today is, look, some 1099 firms are going to stay the course. The law is harder to classify as a 1099 worker, but they didn't come out and say you can never have a healthcare employee who can be classified as a 1099 worker. That's not what the rule says, right? And so to the extent there's still some gray here, some 1099 firms will stay the course. The thing that I have seen in the market, because we get copies of contracts that our clients circulate to us, and this is just a practical tip for all of you, really scrutinize the indemnity language here. We're seeing two models emerge in these contracts from firms that are continuing to stay as 1099. One model just carves out indemnity, right? They will not indemnify. They have an exclusion to the indemnity protections they offer you to say they won't indemnify you for misclassification lawsuits brought on behalf of these employees. And the thought behind that, in their defense, is, look, the risks, right? Like you're buying 1099 labor. The risks associated with that. We shouldn't have to indemnify you, and you're getting a benefit from that. You're getting lower costs. So if you're taking that on, we shouldn't have to indemnify you if the Department of Labor later comes calling. I don't know that that's the argument I would make if I were in your shoes as clients. I would insist on indemnity, but I think that's something you need to look at in the contracts, and I would give you, strong encouragement there to seek full indemnification on any kind of misclassification lawsuit, at least to the extent that the agency you do business with has deep pockets that will provide some protection for you. The worst case here, and I have seen at least one contract like this over the last 3 months. I'm not going to name the firm, but I would encourage you to look at your contracts for this. I've actually seen companies shift the risk fully and demand reverse indemnification on this issue, meaning they're saying your risk is the 1099 risk, and if they get challenged, you would have to indemnify them and defend them in that lawsuit, right? That's a rare provision. I've only seen it in one contract. But I would say watch out for that, right? That's a screaming red flag, and it's something you should be very wary of, right? What are W-2 firms doing in response to this? Look, I think as a W-2 firm, I can speak from our experience, but I also know, I talk with my peers at other companies, they're feeling the same pressures. And it really gets back, Bill, to kind of your comments and Susie early in the presentation. I hear you, Susie, the damage is done, and it's, late to react by an industry, and not going to defend that. I will say most W-2 firms that I stay in contact with, and I know the pressure in our firm is, we've got to get a lot more efficient to still try to make that difference in wage differential as low as possible. We're not going to convince every client that they only need to do business with a W-2 firm. But if that price differential is 10 or 15%, that's a lot easier to defend than if it's 30 or 40% between those two providers, right? And that's really everything we're doing internally, is to become as efficient as possible, strip out layers of management, automate as much as possible, use offshoring, use other help. Tech-enabled matching platforms do make recruiting simpler, easier, faster, right? So that's how we got our founding, and that's what we're focused on. And then where possible, using generative AI to both in the front and the back office, right? So in the front office, use it to aid recruiting and sourcing, so that you don't have as many recruiters running up overhead, and you can pass those savings on to both sides of the marketplace. That's really the core thesis for SnapCare. As if our platform is as efficient as we can possibly make it, we can pass the savings of that platform onto our clients and onto clinicians in the form of better pay, right? It's if we keep that as the middle person, that's not healthy for anyone. The platform needs to make it efficient for everybody. And if we make it efficient for everybody, we can keep these prices much, much closer together. So generative AI, we've seen that in the front office and helping with sourcing, and helping just automate credentialing processes and get things a lot more efficient and clean and faster in those processes. Where we're also using generative AI is in the back office, right? So we just did a training for all of our recruiters. We did role playing. The role playing was entirely done by generative AI, and it was really good. Like, it was shockingly good at how good interacting with ChatGPT in this case was in helping us rehearse objections from candidates, overcome those objections, and also offering tips on how we could have done that better, right? And that means we can have a much more efficient training office. We can have a lot more efficient, processes throughout our operations. So, and I would tell you, we're not alone, right? I'd love to say, I think we're leaders here, but I would tell you all of our competitors are looking at these exact same things, right? We all understand this has to become a much more efficient play. So let's go to the next slide.
If I can,
Yeah, go
can I
ahead.
interject real quick?
Yeah.
I just wanted to share that while you're talking about the things that we're doing and other staffing companies are doing to try to, right the wrongs of the past and, get to a point where the difference in bill rates is not as significant between 1099 and W-2. The healthcare associations, and this is something I've learned from Callie and some of our other business revenue generators are seeing out there, is that they're working in the background to get other relief, not from the rates, but I just learned last week about EQUIP, which is this initiative that the PHCA has put forth. It's enhancing care with incentivized payments, and it's something they're working really hard to get long-term facilities more reimbursements and more quality-based incentive payments, so that also helps make up the difference in the price gap there. So I wanted to call that out just because I know that we've been working really hard to do what we can to narrow that gap, but I also know there are so many other forces out there working to get long-term care facilities the support that they need financially and otherwise.
No, it's a great call out. And I would just say PHCA under Zach's leadership and really his team, and Tim and others, we work with a lot of healthcare associations across the United States. And, I know it's a tough environment. I know you're dealing with a lot of things at once, including, the constant threat of staffing mandates and rates not being what they should be. But you have in PHCA, in my view, if not the best, certainly one of the best, but arguably the best, healthcare association in the country, pushing through good laws and good reimbursement rates, and trying to fight the good fight on thoughtful mandates around staffing. And they've had a great track record of success in that. I think the other thing they've done, a law that I'll mention, Pennsylvania is one of about 5 or 6 states that regulates staffing agencies in the healthcare space. And some of that regulation was pushed through by PHCA to ensure that, against some of the things you're talking about, Susie and Bill, like against, what that law does is it helps make, others in our industry responsible players, right? We are required to have certain levels of insurance. We have to register. Our pricing practices are disclosable. There's any number of things in that law that ensures that those of us who classify as staffing agencies, are thoughtfully regulated and not able to get away with some of the things that happened in the pandemic that really drove rates up and practices to a sloppy place for a lot of the industry. So thoughtful regulation there, and something I want to flag. You guys are very fortunate, I think, to be in Pennsylvania with this healthcare association. Let's go to the next slide. So, a little bit more about SnapCare. What are we doing about it? As I mentioned, we're founded in 2017. We were initially founded as a 1099 platform. We thought at the time that connecting PRN work might work under those laws. We watched those laws develop and concluded otherwise and said, no, we've got to reclassify and become a W-2 firm. We worked very well in the pandemic. I'd like to think we were better than most in avoiding some of the abusive practices that some mentioned earlier. During the pandemic, we specialized in emergency response and moving large numbers of clinicians to large urban areas, working with a lot of the state governments across the country in mass mobilizations in the early phases of COVID. That's how our demand exploded. But I think we find ourselves, and the industry finds itself, at a very different place post-COVID. Most of our contracts are no longer with governments, right? There's not a need for emergency response anymore. And most of our contracts are with clients like you, and they're with, direct providers in the space. And the pain at this point in this industry is super acute. Record levels of bankruptcy, massive wage inflation, lots of things. What I hear most from clients, and I led with this, right? Agency's a bad name, and you guys are taking advantage of the marketplace, and we need control of our workforce back. We want to, some of the themes I've heard in my time in this role all center on the cost picture and the lack of control that people feel and how they're fighting to get it back. And it really forced us to kind of step back and evaluate our business model and think about things very differently. So many companies in our space sell this way, right? And approach you this way. Tell me about your travel nursing needs. Tell me about what your contract needs. Let me help you fill those, right? They start where they want to start. They start where they have an offering. Instead of where we think most of you want to start, which is, I'd much rather have permanent employees filling my needs. I'd rather have a stable workforce that I have working with me, meeting the demand that I have. And only in the exception of a seasonal need or something exceptional will I want to then have to think about contract or travel labor. That's very expensive labor, and I want to use it sparingly, if any. And so I'd much rather start inward and work outward. So we've looked at our platform and said, look, we need to meet this moment, and how will we meet this moment, right? So let's go to the next slide, and I'll talk a little bit more about it. So there's really three main areas we're focused on, and you'll notice a familiar name here. More to come on this in the coming weeks, but you'll see Insight Workforce Solutions here on this slide. We are partnering. We mean it when we say we're about cost control. We know we have to get much more aggressive on rates and to make sure that we are doing what we can to pass the savings of our platform, the efficiency of the recruiting it enables, onto our clients. And part of the evidence of that is, it's not just, we're not just doing this in our name. We are partnering with group purchasing organizations. It's always easier when there's volume to be able to offer lower rates and more stability. And the challenge as smaller providers is, individually, many can't offer that volume, but collectively together, treated as one entity, they can, right? When you aggregate purchasing power across many small providers, as group purchasing organizations do, you have much more influence over market conditions. You have much more influence over rate stability and consistency of compliance. And that's really, that's a partnership we're proud of with Insight, and we're looking forward to bringing that partnership to Pennsylvania. But I cite that more as this is evidence of we really need to be serious about cost control, and it can't just be SnapCare in its own name. Using true procurement help to make this much more predictable and reliable on the bill rates is a critical goal for us. It also can't just be about supplying labor from our perspective. We have to leverage scaled recruiting capabilities and workforce analytics to help our clients optimize their labor mix and maximize their revenue capacity, understanding their bed flow, understanding how many beds they're letting stay idle because they don't have the staffing to support it, understanding and becoming more predictive around patient census data, and then using that to drive staffing models of internal staff utilization first and external staff utilization only as needed. That's really where we believe the market has moved and is moving, and where we need to be better. That's what we're investing in. The last thing I would cite is, to get the most out of analytics, integrations are key. It's very hard to find the money to upgrade your scheduling systems and to, keep pace with the latest and greatest HRIS systems, et cetera. And those of you who are making those investments, it's important to get the most out of them, right? And from our perspective, being able to easily integrate with Kronos or other scheduling tools so that you can see demand in one place and manage your use of labor through your existing platforms rather than having to continually adopt additional platforms is pretty critical. So again, that's where we're investing. How do we make these systems work together to help you understand your future workforce needs, prepare and strategize for your future needs rather than just react to the brutality of the current market? We've all got to make that pivot, not just, I'm sure you're feeling that pressure. We're feeling that pressure too, and we want to be enablers in that. So that's, as we tool our platform, those labor insights are really what we're looking to provide as the value add for existing cost or for lower cost. Let's go to the next slide. Last slide here, just on our solution. The other frame that we're changing is how we relate to our clients and how we talk to them about our needs. Our folks they should not be coming to you trying to talk to you about how can we help you with your contract and travel needs. We want to start where your needs are in perm placement. Are you satisfied with where your permanent placement employees are today? Do you have enough of your own internal workforce, and do you have the recruiting capacity to get it? That feels like a much better place to meet our clients than to go straight to the most expensive form of labor. After that, the next least expensive form of labor tends to be PRN and shift work, and our platform performs well in that space. And so that's another place where we are focusing our energies to say, it's a lot cheaper to meet demand with local clinicians who fill in on shifts as needed than it is to fly travel nurses in. And so how can we help you optimize that before we then talk about SnapCare travel or other kinds of resources? And for larger systems, being able to manage multiple suppliers in one place, we are seeing a growing trend there, and that's another capability we're investing in. I would say though, it's not just about having the product responsiveness. To Bill's point earlier, conversion fees. If you find someone who's good, right? You won't see us be, we routinely waive conversion fees for that conversion. Again, we want to be on your side for the labor you need long-term, and it needs to be a longer-term play, right? So some of those pain points around, you mentioned two, Bill, that I recall earlier. One is in the space of conversion fees. Again, we routinely waive those for our clients. But the other area you mentioned is the pain point of losing people around travel. And we don't do this in every contract, but we do it in most. We will provide, a free training period, 8 hours of training at our expense, right? So you might do the training, but we will cover the 8 hours of training, so that you don't, have, as much risk of loss. But we also do things to incent clinicians to stay through their whole term and through the whole assignment so that you get the perseverance after that training. We have a world-class SnapCare rewards program that we are rolling out, which rewards our clinicians for perseverance. It rewards them for not being tardy. It rewards them for really being fully engaged with our clients. And we want to make sure they feel that investment and that tie to stick through their assignments the whole time. We feel good about where those rates are for us today, but we always are striving to be better. So anyway, that's our solution in a nutshell. I think we wanted to conclude, or at least our prepared remarks, with some pragmatic things that you can do just to kind of make sure you're mitigating your risk here, right? So I don't know, Samantha, if you want to kick us off on this, or Amanda, and then we'll chime in on these. But these are just some practical tips we wanted to leave you with.
Sure, happy to kick it off. These are some of the same questions I think we've talked about along the way. From a legal perspective, doing an internal audit, I think, is kind of step one, looking at these factors and how they're going to be analyzed under the new rule to figure out, do your 1099 clinicians provide their own insurance policies? And if so, how is that verified? Are you tracking that? Are they required to buy the policy coverage that the staffing company recommends, to Rob's point earlier? Another big one, do they work for multiple healthcare facilities at the same time, which can be indicative of a contractor relationship, where they tend to really only use the same staffing company over and over and be going to the same locations. And making sure you're keeping track of where your, whether you're the staffing company or otherwise, where are these workers coming from? Because if you're in an ABC state, that's going to make it a bit trickier. So we recommend typically that the hiring agency conduct an internal audit, determine, do you need to make any classification changes? Now is kind of the time to be doing that without, I get a lot of questions on, well, how do you communicate this? And how do we explain that we weren't doing it wrong? And so they're not owed a bunch of back pay or other benefits. And, how do we not walk ourselves into some sort of collective action? But when you have new regulations come down or legal changes, I think it really opens up the opportunity to say, hey, these changes are coming down the pike. We want to get in front of it. We want to be proactive. So we're just going to go ahead and shift the way we do things. And I think that's typically pretty effective at holding any, ideas at bay that maybe you're doing something below bar, which certainly you're not. I definitely recommend that. Looking at your policies and updating those, whether it's leave policies or training or anything that could be implicated, regardless of which way you're going, and training managers. Managers need to understand what their role is if they're managing employees versus contractors, things like that. So we can make sure we're where it comes into play often is with the tools or training or enforcing policies or denying coverage for something. So we want to make sure that our frontline managers kind of understand the difference here. And of course, seek legal advice as necessary as things change and evolve, because, we mashed all this into a little over an hour, but it can be a lot.
Well, and another thing I want to point out, we looked at some data from a study by Marsh, and they estimated that 75% of the long-term care and senior living space facilities in the United States do not have a workforce management strategy. And I think we've evolved to a place where just traditional, I've got my employees, I fill in every once in a while with another clinician through an agency, that's gone. And so it's really important to look through a whole strategy, not just agency versus non-agency, but analyzing the data, looking at what you truly need, getting the help, the outside help to analyze your workforce and the needs. And so, getting a strategy together is something that I think could absolutely help you save money, but also, give good quality care to the patients. And that's what really matters.
I know we're close to time, but one last point I want to make on this slide is the last point. So this won't necessarily reduce your risk, but it will reduce your exposure if you choose to continue to use 1099 labor, right? There's two things that I would recommend in this last bullet. The first is, I would, if I were using 1099, I'd insist on some kind of reporting that shows none of the workers that are coming to your facility are working more than 40 hours a week, right? Because what that does is it minimizes the risk of overtime penalties and additional liability coming to your facility just from that fact. It doesn't reduce the underlying risk, but it reduces the exposure of major multi-million-dollar penalties if you're able to control that tightly. The other thing that if you're using 1099 labor, I get this question a lot. I used to get it in private practice all the time. I keep hearing I should have a time limit on how long my temporary folks work for me, right? You heard Samantha cover this earlier, and I think I want to again break that down. Much less important to have any kind of a time limit or to watch time limits when your employees are when your workers are in a W-2 staffing firm, because they are having, they're treated as someone's employee, which is the government's concern, right? The government's concern is that they are someone's employee and therefore are getting the protection of tax withholdings and safety, blah, 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 right? Where you really do need to worry about those time limits, though, is if you do have 1099 contractors, I'd be looking at a 3-month rule or a 6-month rule. I'd be very careful about letting any 1099 contractor work in my facility longer than that, because then it's like, aren't they doing the same things all of your other employees are doing? And aren't they, aren't you basically using them to supplant? If you could hire more permanent workers, would you? And would that displace this person? Because if that's all true, then they should be W-2 employees in the eyes of the government, right? So I would enforce some strict time limits around that if I'm in your shoes and choosing to continue to use a 1099 supplier, right? So just a couple thoughts there to be kind of pragmatic about it. I know we're at time. We've been asking for questions throughout, but if there are other questions, we'll stay a little bit long here to answer them. And then certainly feel free to reach out to any of us privately. We're happy to entertain follow-up questions, and we can make in the presentation materials our contact information available.
Thanks. And just to reiterate what Rob just shared, as always, if you do have a question or you think of something after today's webinar, please feel free to reach out to myself, Amanda, Rob, Samantha. If you don't know where to turn, you can always send me your question at kchalia@phca.org, and I will be happy to get your question into the right hands. I'm going to call for questions one last time. Please raise your hand or submit your question in the chat if you have something you want to be heard. I'm not seeing anyone. So with that, thank you so much for sharing this important information with us today. And once again, I will be sharing out the link of this recording when I send out the credit information. Thanks, everyone.
Thank you all.
Thank you, everyone.
Yeah.